Welcome to Planning Ahead with CMS.
In our final episode of our Highways series, we're joined by CMS's Chris Devitt, who is going to talk us through what stopping up orders are and how they impact property rights. Thanks for joining us today, Chris.
Thanks for having me.
In part one of our Highways series, we mentioned that a highway can be closed by a stopping up order. But Chris, what is a stopping up order?
A stopping up order provides a mechanism for removing public rights for the passing and repassing over public rights of way. I'm going to mainly focus on the powers under the Town and Country Planning Act today. This is the route that is most often pertinent to developers. The Town and Country Planning Act permits the making of an order for the stopping up of a highway to allow development to be carried out in accordance with planning permission. For example, a conflict could occur where it was proposed that a new shopping centre will be built over an existing public footpath. It is worth remembering that a planning permission itself cannot provide for the stopping up of highway, and developers should ensure that the necessary stopping up orders have been applied for in good time. The highway, or part of it, should fall within the planning application boundary. The stopping up might also be required as part of an approved plan or a condition of the planning permission.
You mentioned that there are also other ways where you can stop up highways. Could you go through some of them?
Yes, the Highways Act also conveys powers for a highway authority to apply to stop up public rights of way where it considers them to be unnecessary. The Highway Authority can apply on behalf of any person. We see Highways Act stopping up orders most commonly in instances where smaller areas of public right-of-way are no longer being used by the public, and the council and the person applying to the council consider that it is expedient to stop up this land. CMS have recent experience of advising in relation to Highways Act stopping up orders, where the local highway network had become misaligned due to the impact of a series of planning applications bringing forward piecemeal development in the vicinity of a road. These applications had created development which was overlapping but not quite concurrent. The wonky highways boundary was not in the interests of the applicants or the local highway authority. To rectify the highway boundary problem, a series of Section 38 agreements were entered into to create the new desired highway, alongside a series of stopping up orders to remove the now obsolete existing highway.
It would be good to touch a bit on the application process. So when and how can a stopping up order be made?
In respect of highways, an application for a stopping up order under the Town and Country Planning Act can be made at any time before or after the permission is granted, provided that the development authorised by the permission has not been substantially completed, i.e. the development has not built over the highway land itself. An application for stopping up can be submitted at the same time with an application for planning permission, but the stopping up order won't be made until the planning permission is granted. Outside of Greater London, the application is made to the Secretary of State, and if within Greater London, an application is made to the relevant London Council. A stopping up order of a highway can take a minimum of 5 months to be made. If there are unresolved objections, a local public inquiry may need to be held, which can delay the decision for up to 18 months. Developers are also advised to be wary of judicial review periods. These run for 6 weeks from the date that the order is made, but we usually allow a bit longer to allow for the receipt of notices. In most cases, it is advisable to await the expiry of this period before building over the highway.
So do we also have a process for dealing with bridleways and footpaths, things like that, where cars don't go?
Applications for stopping up orders of footpaths or bridleways may be made by the relevant local planning authority. This can take a minimum of 3 months to be made if all objections have been resolved. If objections remain unresolved, the stopping up must be submitted to the Secretary of State for confirmation, and a local inquiry may need to be held. The same points about the dangers of judicial review are also applicable in this instance. With the timings in mind, developers should consider these possible delays when working out project timetables.
So it sounds like a stopping up order could also impact on who owns the land and how that works. Does stopping up affect the land ownership position?
A stopping up order does not affect any private rights of way that exist over the land. Landowners and developers will need to check the title deeds and registers for the existence of any private rights, such as easements, which will continue to affect the land. Public rights-of-way do not affect the ownership of the subsoil. The original owner of the land will continue to be such even while the rights exist. Public rights-of-way exist as a separate legal right which sits on top of the proprietary interests in the land. Once the highway, footpath or bridleway has been stopped up, the public right-of-way will no longer exist. There is a common misconception that highway land belongs to the local authority. This is not necessarily the case, even where the local authority bears the burden of maintenance. If the owner of the subsoil is unknown or unidentifiable following successful stopping up, the assumption of ad medium phylum is applied, where the owners of the property adjoining the stopped up land are presumed to be the proprietary owners of the land up to the medium line.
Wow, such a lot of Latin there, you did well. Thanks, Chris. That's really interesting. Please tune into our next series of Planning Ahead with CMS, where we're going to be talking about affordable housing.